the judge kind of gets into this position where they start to presume differently than the parent, and the judge's opinion of what is in the best interest of the child is the one that ultimately prevails. When a family is involved in a suit for access or possession or visitation with their child, so some third party has come in and requested that a court force the parent to give that third party some amount of time with the child, the most common test that the court uses is what is in the best interest of that child. What's interesting about that is that back in 2000, the US Supreme Court had a decision called the Troxel decision, where they clearly established that it should be presumed that whatever the parent is doing, if they're a fit parent, is in the best interest of the child. What happens in a lot of these court cases, though, is that once you've gotten into court, the judge can overrule a fit parent's decision for their child, even if there wasn't necessarily something wrong with the parent's decision. The judge just thinks a better decision could have been made. It really becomes a difference of opinion between the parent and the judge of how to best parent that child. And so even though US Supreme Court case law tells these judges that they should be deferring to the parent as long as the parent is a fit parent, a lot of times that doesn't happen. One of the obvious solutions to that problem is that you can take the current requirements and put them clearly into the law, so that when you're disputing these cases in court, the attorney has something clear that they can point to that tells the judge, you are required to accept the parent's decision unless you can either prove that the parent is an unfit parent, or unless you can prove that this particular decision they're making is too great a risk to the child for you to not overrule it.